Be rejoining, we're back. Damien will be rejoining us in a minute. Zoom. What's that?
But I hear him.
Okay, I'm distracted.
Sorry.
All right, we are at the very bottom of page 43 with a new section starting on line 18 of safe leave. This is new. It's been presented as a I don't know, it's a separate section because it's 472D. So it would fall under the PFLA section. Question mark? Damien?
It's in the same subchapter.
Yeah. So top of page 44, I think this is a question. So employer here means any person who employs one or more individuals in perform services in Vermont. First of all, does that match what's in the previous sections? And two, committee, between the question here on safe leave is where it falls in the effective dates. Is that according to the effective dates, this would go into effect on July 1, 2023. But there's that which would then either have an inconsistency or a policy choice, because this defines employer as a +1, but goes into effect immediately. Whereas 7 and 8, which are the changes to the PFLA, don't go into effect until 2026. So the unpaid leave portions that say 10 employees for one and 15 employees for another doesn't actually change until 2026, whereas this is going to change immediately. So it's policy, it's either a policy choice or an alignment choice. This would say, if we change it to 10 and 15, it would be available immediately, because it would be just slid into the existing PFLA. If we say it's +1 and goes into effect immediately, it's changing leave policy for this particular issue immediately and keeping the rest of the PFLA the same as it is now until it's scheduled to change in 2026. What's our pleasure? I mean, that's going to be the question that we have for this. I just want to make sure that I've got that right. And it's just something that we have to consider when we talk about this policy. This will open up safe leave on the same limited basis that PFLA exists right now. And it wouldn't, if we go to 10 and 15.
Right. So it would be probably one or the other for purposes of this, because unlike parental and then family/medical leave under the PFLA, their safe leave is safe leave. So you're talking about leave related to an incident or incidents of domestic violence, sexual assault, or stalking. It covers everything from the legal aspects to the medical aspects to possibly relocating for safety. I'm not sure you could do it. I'm just not sure how you would draw a line on those different things in the same way you can between parental leave and the medical sorts of leave.
Right. But if we want to add this protection, again, the question is, if we add it immediately, what's the level of employers? Do we want to change what's already in law immediately? Or do we want to align it immediately with what's existing, just 10 and 15. Right. And so that's a policy conversation for us to have, because it's a pretty substantial, it's not a technical change, pretty substantial policy choice.
Yes. As far as the definition of employer, there's a slight inconsistency between this one and what's in the PFLA changes.
Yeah.
The words "to perform services" on line 2 are not in the other definitions. They're in this definition. There's really no advantage to keeping them. If you're going to go one or more employees, just say one or more employees. This was just
A vestige.
it was just, the difference between me drafting this on one day and not the day before. So.
Senator Bilton.
Yeah, the perform services piece, I'm just wondering about, like, we did a telehealth, bill last year. So for mental health services, if someone was providing mental health services to somebody in Vermont, they work for a company that's based out of Vermont, does that count? Because they're performing, the services is being received by someone in Vermont, but they're not in Vermont.
Yeah,
Services.
it does raise some questions like that. This comes out of a lot of the independent contractor bills, where we would talk about employing someone to perform services, which includes everything from making a widget to working at a cash register to building a house, to providing healthcare services. I take your point, though, that this could be in the days of telehealth and remote services for all sorts of things, now that everybody exists half their life on Zoom and other remote platforms. Just saying employs one or more individuals in Vermont, which is what we use in the others, probably makes more sense. My concern as an attorney is just so the rule of construction when you get to the court is that the legislature does not enact surplusage, which means words that are unnecessary. Which those of us in this building, we know that that's not true. But the court thinks that we do everything advisedly and don't ever unintentionally leave words in a statute that we didn't mean to have there. So as an attorney, my concern would be that at some point you would have someone who we intended to cover or intended not to cover who then gets covered. And it could be that telehealth employer where they're located in California or Canada or who knows where, but they're providing services in Vermont. And so then suddenly they get wrapped up in this bill and we didn't intend to cover them, or there's an employee who we intended to cover who doesn't get covered for the same reason, because they're employed by a Vermont employer, but they're performing services, or they perform services across state lines, even though their business is domiciled here, they're paid here, their home office is here, et cetera. So I would recommend taking out the "to perform services" language just for consistency.
We'll make that, yes, perhaps, but just also when we have the conversation over that sentence anyway, just whether or not we want, when do we want employer to change? Or how do we want to make this fit?
So do you want me to flag the employer definitions across the board for discussion?
No, because it's clear, it's clear in the other sections that the change in employer in PFLA is not going into effect until 2026.
So flag
The program, the Family Medical Leave Program is not going into effect until 2026. So those two align. It's just this one either doesn't, again, we either have a choice of we want this to go into effect immediately, if that's the case, at what level? If it's 10 and 15 to align with the existing PFLA, then we have to change this definition.
Okay.
Because if it's going into effect, yeah, so I think that's what we're, if we want it to go into effect and it's 10 and 15, then we have to reflect that. Which leads to the second question here, which is letter A. We've cut the definitions of what an employee is in previous sections to say.
We've actually kept the A and B in the other sections. So
About the 6 months and the 30 hours or 20 hours in this
it's
case?
12 months and 30 hours a week. I was asked to draft this as 6 and 20 to set a lower threshold. So current PFLA, in order to be eligible as an employee, you have to have worked continuously for your employer for 12 months and an average of 30 hours a week. This would set it at 6 months and an average of at least 20 hours a week. So half the duration and a third fewer hours, which would open it up to more employees. The other piece is during the 2 of the last 4 completed calendar quarters. This gets back to, in part, to the chair's question about the timing, whether you want to phase in the employer language too, so that it starts off at current law and then adds in consistency with the insurance provision on the date that that's set to take effect. But the reason we've set it up as either or is because if you have a long-term employee, so we'll go back to that Massachusetts employer that expands into Vermont. If they send up one of their long-term employees to manage their new branch in Vermont, that employee may have worked for them for 10 years, 40 hours a week on average. They should be eligible for safe leave, but because they've only been in Vermont for 2 weeks, if we changed it so it just being those contributions, you would take people that we would have protected under the old law and now exclude them from protection simply because they hadn't paid taxes in Vermont for long enough. So the idea was to keep the protections in the old law for people who may not be eligible for the paid leave benefit, but to still give them the protection in the PFLA, in particular, give them that protection if they get diagnosed with, a serious disease or something like that right after they arrive here. But then open it up to anyone else who's able to take the insurance. So you really have 2 questions here. One is, are the eligibility levels appropriate from your policy perspective? The other is, do you want to phase it in so that B takes effect in 2026 when leave benefits take effect? Because otherwise, this is kind of a strange one to have in there on July 1 of 2023. Because it references an eligibility for a program that is 3 years and 3 months out from taking effect. So
Just flag that, please. I think I can straighten that out. Down to letter B. Again, an important piece. In addition to any other leave provided pursuant to the subchapter, does that mean all of the paid leave that's the PFLA, an employee shall be entitled to take up to 12 weeks of leave?
right, so that subchapter, if we want to just take a quick trip here. That subchapter includes PFLA. It also includes short-term family leave, which is leave for something like a doctor's appointment or a school conference. So here's the parental and family leave law. It also includes town meeting leave so that you can get leave from work to go vote or participate in your town meeting. It includes leave for alleged crime victims who are seeking a relief from stalking or abuse order. So this is just basically saying that this isn't combined with all of these other leaves, it's in addition to. So that if, for example, you took a parental leave earlier in the year, you can't be denied leave if your partner then begins to abuse you. So does that make sense?
Right, it operates really separately
Yes.
from the 12 weeks of job protected leave. This is providing job protection up to an extra 12 weeks of unpaid job protection.
Yes.
It's not necessarily like it can be paid through the FMLI.
Mm-hmm.
The
It could also,
FMLI doesn't get extended to 24 weeks.
right. So, yeah. So in 2027, if everything happens the way it is in this bill, we'll take that situation I just talked about before, where an individual takes parental leave for 12 weeks. Then later in that same 12-month period, they become a victim of spousal abuse or intimate partner abuse, and they need to relocate. They are not entitled to the state paid leave insurance benefits, but they are entitled to job protected leave from work, even if they have to take it without pay. So that's what this would do by saying it's in addition to, is you could use up the paid leave but you could still get job protection. So there are a variety of questions I could kind of highlight for you here, but I think that the important thing to understand is that you could end up with the way these particular laws work. You could end up with multiple different unpaid leaves on top of your job protected leave that you used the family and medical leave insurance benefits for. So whether it's time off, 2 hours off to go to a child's parent teacher conference or to a health appointment, or it's time off to go vote at town meeting. There are other instances where you could take job protected leave, not all of which get wage replacement from the state insurance program that's proposed in this bill.
Right, because they don't fit.
Mm-hmm.
So starting at line 16, so it's take up to 12 weeks of leave in a 12-month period if, and then we have the A's and the B's to give us the qualifications for applying and using that leave, which are different than medical leave and family leave.
Yep.
Line 10 allows for use intermittently. And this is phrased slightly differently than the paid leave portion, which is just says shall be entitled to leave. The increments are not less than 1 day. And it has to be different than, I think it has to be different than the paid leave section. Because we're talking about, well, whatever, you tell me.
So it tracks pretty closely. The drafting decision was set to do the leave increments at not less than 1 day. You could set that lower. There's nothing that restricts you from doing that. So you could set it at increments of 1 hour or 2 hours, something like that. But the thinking and drafting this was that we're setting the paid leave benefit at 1 day at a time. And so we'll just set this at 1 day at a time. Some of these qualifying reasons could definitely take less than 1 day. Others, like a court appearance, could eat up an entire day easily. So,
Which speaks to, which actually goes down to line 17 is like, if there's a leave needed to be taken and is foreseeable, the employee provides the employer with written notice of the need as soon as possible. So obviously if there's, like, if you have a court date, guessing that it's going to be 4 hours instead of 8 hours is,
yeah.
yeah, Representative Elder.
What about jury duty? Because that's something that, like, if your employer doesn't pay you for it, you're self-employed, it pays like $30 a day. I'm not sure how it's legal, but anyway.
We get paid 30, I'm just kidding.
Hardly.
So would there be any, remuneration for such person? Like, could you get paid for your jury duty out of this program?
No, because you're not a victim of, if you're
there's nothing-
taking the leave for the jury, it's not because you're a victim of domestic violence.
Oh, right, because this is just a safety.
Yeah. Yeah.
Right, and the other wouldn't count. So the
Right.
court date is entirely about related to.
Yeah, that's entirely related to
Right,
legal
of course.
proceedings related to,
No, it's here in the court, yeah, that makes
yeah.
sense. Next.
yep.
Representative LeBounty?
Just for clarification, on page 45, when on line 12, for not less than 1 day, so what you're saying is that if I have a doctor's appointment in the morning, like at 10 o'clock, I can't take like 4 hours off and then go back to work for 4 hours?
The way this is set up, no, you can't. So,
Use sick leave though.
you could use
Yeah.
sick leave.
Yeah. Use CTO.
Yep, you could use that.
But we can have enough.
Right, so the balancing question here is really the issue of, so this was set up, like I said, it was basically balancing the leave increments against the increments in which the individual could get paid under the family and medical leave insurance program that's being set up. It wasn't looking at what's the smallest increment that we want to kind of set out for folks to take leave. But you could change that. That's a policy question.
Yeah, see, I had radiation treatment and I had it for 6 weeks, 30 days in a row. And the treatment only lasts like about, within an hour, I could be there and be done. And I didn't have to take a day off, be charged a day every day for 30 days.
Right.
Well, real life, well, I'm not going to venture in that, into that area.
So I think under the existing PFLA and FMLA, the intermittent leaves can be set up in a shorter time period. I have to check exactly what the requirements are on that. But you could shorten this down to that. And individuals are allowed to use other forms of wage replacement. The question that you would potentially get into if do you want to, in the disqualifications for the paid leave insurance program, do you want to say that on a day that you're receiving wages, you cannot also receive paid leave insurance? Because that, right now, that's paid in increments of a day. And what you're describing are days where you could be out of work for an hour. You don't have to miss the whole day. So you could easily cover that with, it's protected under the job protected leave, but you can also cover that with your sick leave allotment. 30 hours of sick leave is less than the amount of sick leave you're provided in a year by the state law. So that that kind of gets into just some of the nuances of how do you want to structure this.
Yeah.
And if we're going to get back to this question of someone double dipping, which was discussed last week, there's just the potential with, if you're taking an hour of leave at a time and you're claiming a day of paid leave benefits, that you're almost, I hate to say incentivized, because something like radiation treatment is obviously extremely important and possibly life-threatening if you forego it. But economically, there's at least the appearance that you have an additional benefit for taking these leave benefits here to undergo that treatment, which again, I don't want to be misconstrued as minimizing the importance of getting that sort of treatment. So it's just something that kind of hit me. In unemployment insurance, the way it's written is basically you can't claim unemployment for a day that you receive wages unless you're qualifying for partial unemployment, which is a separate program within that to encourage people to get back to work, even if they can't find full-time work. But we could write something in like that where you can't claim it for a day that you're receiving wages or payments of accrued paid leave. And that way the state program is not subsidizing people who are being paid by their employer for the day.
Okay. So then there's the notice of the leave, it should be made, it's, unless there's an emergency, which takes us to the top of page 46.
There is actually one other thing that I'm glad Representative LaBounty stopped me at line 12, because on line 14 to 16, this was brought to my attention on Friday afternoon. So the language here, you'll notice, says that during the leave at the employee's option, the employee may use accrued sick leave, vacation leave, or any other accrued paid leave. It's missing the family leave insurance program and also short-term disability insurance or other insurance that may cover some forms of leave here. Again, there's a phasing question here, depending on the effective date. But depending on which way the committee goes, I can draft around that. I just wanted to highlight that as something that was an oversight on my part in drafting. And presumably it is an error that should be corrected, so.
Okay. So top of page 46, 2A, line 3, employer may require an employee to provide documentation of the need for the leave. And it lists off the different choices that can be used, including self-certification on line 11, which would be signed under the penalty of perjury. So it wouldn't just be, it would have to be true, or else the employee could be held liable for perjury.
Mm-hmm. This was raised by some of the advocates here. The phrasing on lines 3 and 4 implies that the employer could decide what the form of documentation has to be, which could create problems for individuals who, for example, are relocating but don't want to get law enforcement involved with a family member. So they haven't filed a police report, but they're relocating to be safe. So I think the suggested language was a period after need for the leave, and then an employee may elect to file documentation from one of the following, or may provide documentation from any one of the following sources, not elect, because the employer can still require documentation.
Okay, Representative Bartley.
Sorry, can I just really quickly back up a little bit to line 8? The employee is not the alleged perpetrator of the domestic violence, sexual assault, or stalking. What if it is a domestic disturbance? and both parties have some sort of injury, or what would happen in that case? Would they both be able to take some sort of leave? And this might just be my ignorance regarding the matter.
This is tied into,
Sorry, let me back up.
Sorry.
No, that's okay. I just needed to get the
I
note.
think this is tied up to, well, it finishes kind of concept in a way of on line 44, the end of section B1, where it just, or B1, which says, an employee shall be entitled to take a leave. And this is just saying, but the employee is not the alleged perpetrator. So
And what,
if I commit if I've been accused of domestic violence, I can't take this job protected leave.
and what you're talking about is a situation where law enforcement is called to a residence and they take both parents or both partners into custody because the partners were both harming the other one.
Yeah.
It was a fight, and law enforcement is potentially charging them both with the domestic disturbance. I am not sure. As I read it, I think that potentially in that situation, the individual could not claim leave under this.
Okay.
And I would want to consult with Michelle just to see if there's a better way to phrase it, if the committee's desire is to include that situation. Because this looks at it as sort of a one-sided, but if you're both being charged with domestic assault, then I could see that being problematic.
All right, so lines, down to line 19 on page 46, where an employer shall not disclose any information received except to the extent consented to by the employee in writing, required pursuant to a court order or required pursuant to state or federal law. So that's privacy. It's a privacy issue, so that it speaks more towards the reluctance of folks reporting. Is that, I mean, or how the employer can use the information when an employee is reporting?
Yeah, so this is to protect employees' confidentiality. So the employer, well, the employer here is basically required to keep this confidential in the same way they would health information regarding an employee. So you can't disclose it unless, one, you've got written consent from the employee, or two, you're required to disclose it either by an order of the court or under state or federal law. So the idea is to protect the employee's confidentiality, except where the law requires otherwise, or where the employee has waived that confidentiality. So the goal here is to avoid an instance where someone takes their job protected leave, but then has word of their situation leaked out, which causes further harm to the employee by disclosing the private situation that they're facing and the reason for the leave. It's the same way that right now, if someone were to take leave under FMLA or PFLA, as an employer, apart from people who need to know for purposes of administering the leave, you cannot disclose the reason for that leave. So you can't say that Damien is taking leave because he's got a disease or because he is recovering from an injury or whatever it is, you can't disclose the health condition. You can just say Damien's on leave for the next 12 weeks. That's it.
Okay.
So,
All right. So line 3, really through the end of the document or the end of the section is language you've seen before. It talks about the employer shall continue employment benefits during the leave, posting in a conspicuous place, printed notices. Upon return from leave, the employee shall be offered the same or comparable job. Section 2 shall not apply if prior to requesting leave, the employee has been given notice or had given notice. And subsection 3 shall not apply if the employer can demonstrate by clear and convincing evidence that during the period of leave, the employee's job would have been terminated or the employee would have been laid off for reasons unrelated to the leave. Section H, the employer may adopt a leave policy more generous. Line 5, section 2. This shall not diminish an employer's obligation to comply with any collective bargaining agreement or any employment benefit program. Section 3, collective bargaining agreement shall not diminish the rights provided by this section. Which again, I don't want to call it, I mean, I guess it's boilerplate, but we've seen it elsewhere. And then the effective dates. So as we mentioned, sections 7 and 8 take effect on October 1, 2026. Everything else would take effect on July 21, 2023. And of course, that doesn't mean that the paid leave program would start that day. It would just mean that it would start to be built that day.
right, and then C kind of tells you when contributions begin being paid and when the benefits begin, so.
It's page 48, folks. So Damien, what's next?
Well, I'm currently marking up the draft. That's gonna take a while. But I'm working on your schedule, so I think you also wanted additional information from Patrick here about some numbers. Good timing.
Entrance, Patrick, perfect.
But yeah, at the moment, I'm working to mark up the draft and get that ready. I think Ron has me scheduled for tomorrow afternoon. Is that right? Or morning is tentative on my calendar, so.
You indicated you would need to be next door for a half hour or so?
Yeah, I have, sorry.
Anyway, I have you scheduled anytime you're not somewhere else. That you told me about.
Yeah, I'm next door till 10 o'clock tomorrow morning, I think. But otherwise, I think Ron has scheduled me from 10 until 6 o'clock tomorrow night, with a break for lunch. So.
And the floor and.
Right, what time is your floor tomorrow?
3.
Oh, okay, good to know.
And there are a number of bills that don't know that they're long bills, but doesn't matter. The floor is at 3 o'clock and then we'll come back after that. So would it be possible for us to have a draft to work from tomorrow morning?
I can certainly try.
Because if we have a draft that's at least available electronically or that we can print out, for people who need it printed out, then that would be fabulous.
I think realistically, the question is, do you want the draft edited at this point, or do you want to just work off a rough?
I think I want to work off of a rough draft because I don't want to, if we have to wait, then I want us to wait after we did work on it rather than have it edited once.
Yeah, so what I'll do then is I'll give you an unedited draft to work from, and I'll have something ready for the morning.
And please just let committee know what the difference, how we should be looking at unedited drafts versus edited drafts.
So, as you may or may not know, for those of you who are new, I have a team of 6 people that makes me look good. They're the editors. They catch my typos, my grammatical errors, my formatting errors, places where I repeat myself. And so they right now, though, for all of you, are working furiously to get the drafts of your bills out so that you can sign them out for introduction by next Tuesday. Plug to get your bills in for introduction if you have any outstanding, and do it sooner rather than later. So they're right now working furiously on that. So they are prioritizing markups for committees, but to the extent that you can take that load off of them, they would appreciate it. So when I send you an unedited draft, I'll put a watermark on it and a little red heading at the top that lets everyone know that if there are typos and grammatical errors, those are not intentional and they will get fixed. It's just, this is the rough language.
Okay, thank you.
But yeah, I'll make way for Patrick if there's nothing else for me, and go downstairs and keep working on that while I listen.
That actually came down and have a word with you.
Oh.
I think he's ready to.
Oh, you're not ready to talk.
All right,
Sorry, Pat.
so, let's let Damien go. Let's take 10 minutes. I'll talk to Patrick and see where he's at, and we'll come back and then perhaps either have some conversation or we'll just wait for the next draft to have our conversation. But thank you for getting through this. It's 48 pages. 46 pages after the list, but still, thank you all for your patience with getting through the questions so far.